Are you ready, Ms. Price?
Yes, sir. Forgive me. I don't think you heard, or the connection wasn't there. Good afternoon.
Good afternoon. I think before you call the next witness, I wish to make a short statement and issue an invitation. Is the witness in the room?
No, sir, he's not.
So the statement I wish to make is as follows. Throughout phases 2 to 7 of this inquiry, those following it will know that most of the questioning of the witnesses has been done by Mr. Beer and his team of counsel. However, you will also know that it's often be the case that counsel for core representatives ask supplementary or additional questions of the witnesses as we've been going along. What may be less well known is the process by which that comes about. And without going into too much detail, essentially what happens is that counsel for the core participants submit lists of questions that they wish witnesses to be asked about, and then counsel to the inquiry decides whether they will ask the question themselves or whether they will leave it to counsel for the core participant to ask the particular question. And that system has worked extremely well, and I should say here and now that I'm very grateful to all counsel involved in this process who's made it work so well. Very occasionally, as I understand it, counsel for a core participant may wish to ask a question which counsel to the inquiry thinks ought not to be asked. In those circumstances, counsel to the inquiry does not have the last word. That would rest with me if any application is made to me to ask the particular question or a line of questioning. To date, I've never been asked to exercise my power to determine whether or not a question should be asked. And that's pretty remarkable given that we're, almost 3 years into this process. Anyway, intelligence has reached me that there may be a problem, and I stress may be a problem, to be resolved in relation to questioning of Sir Alex. And so I wanted to raise that immediately before he begins his evidence. And the invitation I make is simply this. If there is any co-participant who feels that they are being deprived of the opportunity of putting a question to Sir Alex because of some kind of suggestion by counsel to the inquiry that the question should not be asked, now is your opportunity to raise it with me so that I can have the last word on the subject. So if anybody does wish to make any application to me, will they please do it now? Any takers, Ms. Price?
It doesn't appear so, sir.
Fine. Then let's have Sir Alex into the room, please.
Thank you.
I swear by Almighty God
that the evidence I shall give
shall be the truth,
the whole truth,
and nothing but the truth.
Thank you. Please take a seat.
Could you give us your full name, please, Sir Alex?
Alexander James Chisholm.
As you know, my name is Emma Price, and I'll be asking you questions on behalf of the inquiry. Thank you for coming to the inquiry today to assist it in its work and for providing a detailed witness statement in advance of today. You should have a hard copy of that witness statement in front of you. Do you have that?
Yes, I do.
It is dated the 14th of October 2024. If you could turn to page 68 of that, please.
Yep.
Do you have a copy with a visible signature?
I do.
And is that your signature?
It is.
I understand there's one minor correction you'd like to make to the statement.
Yes, thank you very much.
Would you like to tell us what that is?
It is a point of detail. Paragraph 23, and I'm talking there about the funding given to Post Office Limited by the department in my time. And in the fourth sentence there, we talk about the subsidy over 3 years and then the investment. And it says the investment was 168 million in 2018-19, with the remainder of the 210 million funding earmarked for the next 2 years, and it should be the next year, just 1 year, not 2.
Are there any further corrections to be made?
No.
With that correction made, are the contents of the statement true to the best of your knowledge and belief?
Yes.
For the purposes of the transcript, the reference for Sir Alex's statement is WITN 001-80100. Sir Alex, your witness statement is now in evidence and it will be published on the inquiry's website in due course. I will not therefore be asking you about every aspect of your statement, just certain matters within it. I'd like to start, please, with your background and the roles that you have held, which are of relevance to matters being looked at by the inquiry. After you graduated from Oxford with a degree in history and completed a Masters of Business Administration, you began your career as a civil servant in 1990, is that right?
Yes.
You worked in various roles at the Department of Trade and Industry and the Office of Fair Trading until 1996. You then worked in the private sector for around a decade before returning to public service in 2006, when you were appointed as Commissioner at the Commission for Communication Regulation in Ireland.
Yes.
In 2013, you were appointed as Chief Executive of the newly formed Competition and Markets Authority and held that position until 2016.
Yes.
You then served for a short period in the Department of Energy and Climate Change as Permanent Secretary.
Yes.
Then, following the merger of the DECC with the Department for Business, Innovations and Science to create the Department for Business, Energy and Industrial Strategy, you became Permanent Secretary of BEIS on the 5th of September 2016.
Yes.
You remained in that role at BEIS until the 13th of April 2020.
Yes.
You were then appointed as Chief Operating Officer for the Civil Service,
Yes.
and in parallel Permanent Secretary for the Cabinet Office, roles you held until April of this year, is that right?
Correct.
And you are now Chairman of EDF Energy.
Yes.
Coming to your responsibilities as Permanent Secretary of BEIS, please. As Permanent Secretary, you were the senior civil servant with lead responsibility for the management and oversight of the department and its resources.
Correct.
You were the Principal Accounting Officer, the Senior Advisor to Ministers, and a public representative of the department. Is that right?
Yes.
You also chaired the department's Executive Committee and represented the department before the Public Accounts Committee.
Yes.
You set out the many and varied matters which were occupying the department in 2016 and the years which followed at paragraphs 11 and 12 of your statement.
Yes.
You also explain in your statement that the department at that time sponsored over 40 arm's-length bodies or partner organisations, as they were known within BEIS. Is that right?
Yep.
You deal at paragraph 15 of your statement with your particular responsibilities as the department's Principal Accounting Officer. Could we have that on screen, please? It's page 4 of WITN 001-80100. And here you explain that as Principal Accounting Officer, you were accountable to Parliament for departmental expenditure. This covered funds directly spent by the department, for example, the funds required to employ the approximately 4,000 staff who worked at BEIS, It also covered funds spent by over 40 arm's-length bodies and capital programmes. And then you give an example for 2008 to 18 to 2019 of the expenditure of the core department and agencies being £13.6 billion. You describe Post Office as one of those arm's-length bodies or partner organisations in the paragraph below. Was that how the Post Office was categorised, notwithstanding its status as a public corporation?
Yes, I think technically, under the scheme of accounts, the Office of National Statistics would classify it as a public non-financial corporation, and that, or often referred to as a public corporation, and that put it at even further arm's length than the arm's length bodies. For practical purposes, we treated them as one of our partner organisations. It is the case, though, that when I talk about 40,000 people working within the departments and its agencies, that doesn't include all the people who worked in the Post Office, which was a separate business, and of course, tens of thousands of further people were working there.
Okay, just on that figure, I think it was 4,000 in paragraph 15 that you gave. Is that supposed to be 40,000?
No, 4,000 in the core department and a further 40,000
I see.
Working for us in the arm's length bodies, but that didn't include several tens of thousands more who would have worked in the sub-postmasters.
I see.
So,
To deal with your accountability for Post Office's funded expenditure, you deal with this at paragraph 45, which is page 12, please. And you say, whilst I was not involved in the detail of UKGI's oversight of Post Office Limited, as Principal Accounting Officer, I was accountable to Parliament in respect of Post Office Limited's funded expenditure, as defined above, and for ensuring that arrangements were in place for effective shareholder oversight. So, to be clear, first of all, about the parameters of this, you say at paragraph 23 of your statement that at the time you were Permanent Secretary, Post Office Limited was mainly self-funded through paid-for services, but in addition it benefited from top-up funding from His Majesty's Treasury. Your accountability as Principal Accounting Officer for the department to Parliament for Post Office Limited's expenditure, was that limited to expenditure funded by the department?
I think the scheme, the way it works is that as Principal Accounting Officer, you then give delegated accounting responsibility to either people working in your own department or usually the heads of the arm's length bodies. And in this case, the accountable officer, it's not called accounting officer for, again, a very technical reason, apologies for that. The accountable officer was the chief executive of the Post Office. And you could see when I made, for example, the appointment of the new accountable officer, first Al Cameron and then Nick Reed, they get a formal letter from me, a formal delegation. That would have been done for the Paula Venables, who was appointed before my time as accountable officer. And that says basically, I'm the principal accounting officer, I'm now holding you responsible for running this organisation, the public money within it, upholding the standards of managing public money and all the other things. It's all set out in a formal letter of delegation. So that's the first part of it. I think in addition, as part of that, you don't say, right, well, that's it. You remain concerned that oversight is working effectively. You're there to provide advice and support to the accounting officers. You can see, many times in those meetings, one-to-one meetings and so on, you're saying, what are the issues and how can we help you with those? Also, there is, I have to say, a supervisory aspect to it. So you're also making sure that they are doing things correctly. And in my time, I don't know if you're going to come to this, but at one point we found evidence that they were using funds that we had given the Post Office for the purpose of maintaining the network and investing in transformation. They appeared to have been used for a piece of litigation, and we said
yes,
that was incorrect.
Yes, we will come on to that.
Yeah, but it's an example of the exercise of that principal accounting officer function.
The inquiry has heard evidence from Sir Martin Donnelly that at least at some stage of his tenure from 2010 to July 2016 as Permanent Secretary of the Department for Business, Innovation and Science, for most of the partner organisations over which BIS had oversight, their accounts were consolidated into the main BIS accounts. This did not apply, he said, to Royal Mail and to the Post Office, given their status as a public corporation. Can you help, please, with whether the accounts for any partner organisations were being consolidated into the main BEIS accounts when you were Permanent Secretary?
I have to think about that. I think very likely they would have been for some of the executive agencies, but I'm not absolutely sure of that. And they might have been for, yes, so for example, the Nuclear Decommissioning Authority, I think those accounts must have been consolidated because I remember that we had to make provision for change in the interest rate. Yes, so probably quite a number of them would have been consolidated. I think that is right, yeah. If it's important to the inquiry, I could check the detail of that, but it's all there in the public accounts. Yeah.
In relation to the Post Office, its accounts weren't consolidated into
No.
the main accounts. What was the reason for that?
It was treated as a company, run as a business, very much at arm's length. It had its own statute, it had its own board, a fully fiduciary board. Its accounts were published, produced to the requirements of, like any other company. They were externally audited, not done by the government's auditors. All of that was done on a completely separate basis. And I think it's also the case that unlike other parts of the department where we'd be employing civil servants, here obviously it's much like a business, like a franchising business with lots and lots of employees. Quite a big business, I think about $1 billion in turnover at that time. And its accounts would have been more comparable to those of another retailer than to something within a government department.
Was there any difference in your principal accounting officer responsibilities as they related to the Post Office when compared to other partner organisations, in particular partner organisations which were not classified as a public non-financial corporation?
Yes, I think that those which were closer and more like to us, we probably, if they were consolidating the accounts, we'd have had more control and involvement and also more day-to-day responsibility. I say again that as a public corporation run like a business, it was very much at the outer edge of that arm's length responsibility. And in the delegated authority that we gave them, it was clear that they needed to exercise their own control, internal financial controls, proper audit, proper processes, proper supervision, as you'd expect in any other company or business.
To what extent did you get involved in overseeing Post Office's accounting practices?
Accounting practices, I would say not at all. I think the only exception I can think to that is we had a funding agreement, it was called, and actually I just drew attention to the funding we gave both the network a subsidy to make sure that there were approximately 11,500 post office outlets, and also we funded some investment they were making to improve their efficiency and transformation. So those were the two pieces of direct BEIS funding came from the Treasury through us to the Post Office, and we were very meticulous in making sure they were spending those in the right way. They had to account for how they were doing it, and that's how we detected that they had used a small part of it incorrectly for litigation, which they then had to repay to us, and were then put on a kind of extra attention of monitoring and reporting every quarter thereafter that they had not repeated that error.
We'll come to the correspondence on that very shortly. So, broadly speaking, it was the case instead that you had oversight responsibility for ensuring the proper use by the Post Office of public funds for their designated purposes, as opposed to being more intricately involved in their accounting practices.
Yes, I mean, in effect, the responsibility I had as Principal Accounting Officer was then passed on to the Chief Executive of the Post Office, who was the accountable officer.
The example that you've referred to of your correspondence with Paula Venables in respect of use of public funds for the litigation, could we have on screen, please, POL 30240773? This is a letter you wrote to Paula Venables on the 3rd of January 2018, which raises your concern about a recent funding request which had been made of the department. Starting at the second paragraph down, you say, as you will be aware, the Minister wrote to Tim Parker on the 20th of December 2017 to set out the basis for providing transformation funding to Post Office and her expectations on how this was to be used. The Minister emphasised the need for funding to be used prudently and efficiently in accordance with the objectives of the 3-year strategic plan, whilst recognising the need for some flexibility for a commercial business engaged in investment projects. In your recent funding request, you indicated that you intended to use BEIS funds for a non-transformation related spend, specifically in relation to the ongoing Horizon litigation. I understand this is now no longer the case, and UKGI have communicated to your team the requirement for BEIS funding only to be used against those projects which are related to transformation or approved investment activities. You go on to explain that as Principal Accounting Officer, you are personally responsible for ensuring the department has a high standard of governance and exercises effective controls over the management of resources, including those through its partner organisations, so that I may have ongoing assurance that BEIS funds entrusted to Post Office are being used as the Minister intended. Please can you confirm this on a quarterly basis in arrears? UKGI will provide you with further details on wording and format. So it was your view that the use of departmental funds for the Horizon litigation was not a proper purpose for a proper use for designated purposes, is that right?
Yes.
You go so far as to describe it in your statement as a categorical mistake in budgeting and reporting. Paula Venables responded to you by way of a letter dated the 8th of January 2019. Could we have that on screen, please? It's POL 30240774. She addresses the litigation funding issue starting the 4th paragraph down and says, we operate a single portfolio of large change projects which form the basis of our reporting to the board. As you know, our change funding comes from a combination of Post Office trading profit and government transformation funds. The GLO work draws on shared scarce resources from this change budget. We have been transparent about these costs. I will ensure we make it clear that the source of funds for GLO work is Post Office, not government. When this was brought to our attention in December, we removed the £2.4 million from our quarterly request. We will not include GLO spend in future funding requests and will confirm this quarterly, agreeing the wording with UKGI as requested. She goes on, furthermore, to ensure that the distinction is absolute and consistent, I have asked Al Cameron, CFOO, to arrange for £2.3 million to be returned to BEIS. The GLO was listed in our earlier reporting, and we received funding from you of £2.3 million for Q2. Did you personally review the quarterly funding requests from the Post Office?
No.
Was that something you delegated to those who worked to you?
Yes, the oversight of that was done by UKGI, and I think it's extremely likely that they drew my attention to it. It's possible I spotted it myself, but more likely they said, we've been going through the returns from the Post Office and they appear to have been using some of our money, inverted commas, Bay's money, not for the reasons given, which was specifically for network maintenance and transformation, but for litigation. We think that's wrong. Do you agree? And I saw it and I said, yes, I absolutely agree, and we should change that, and we should require them not only to give us the money back, but also to make sure it never happens again, which I think is the effect of the commitment that's entered into by the Chief Executive in that letter.
So you were told, were you, by UKGI about the previous earlier reporting and the payment out that had been made, in addition to the recent report? Because there are two things referred to here. Was it that you were hearing about the previous reporting for the first time in this letter from Paula Venables, or had that already been reported to you?
I hadn't noticed at the time there was a difference between that. Now you mention it, I see 2.4 million is different from 2.3 million. So it may be that they did it for 2 quarters. But anyway, you know, when I saw that, I thought, good, they've paid the money back and they've accepted they made a mistake and they won't do it again. Yeah.
Was the 2.3 million returned by the Post Office to the department as promised?
I'm sure it was, yes.
Were you reassured by Ms Venables' response to your challenge?
Yes, in the sense that they didn't argue that they'd made a mistake. They said, we've made a mistake, we've made it good, we've paid the money back, and we will, you know, continue to account for you in this a special way to make sure it doesn't happen again. So I thought that was satisfactory. I mean, it wasn't good that it happened in the first place, but at least they had accepted their error and made amends.
That document can come down now, thank you. In terms of your wider responsibility, beyond being accountable for Post Office's expenditure of public funds, you were responsible for ensuring that arrangements were in place for effective shareholder oversight of Post Office. Is that right?
Yes.
Was it in the context of that responsibility that you began work in 2018 on a new shareholder relationship framework document to clarify the respective roles and responsibilities of BEIS and UKGI as they pertain to Post Office?
Yes.
We'll come back in due course to the reasons why you considered that necessary. But just in terms of involvement on shareholder issues, you say you were actively involved on core shareholder issues throughout your tenure. Is that right?
Yes.
And you give examples in your statement of issuing guidance letters to the chair of the Post Office, appointing the new CEO following Paula Venables' departure, and involvement in Post Office strategy setting and discussions.
Yes.
In terms of the government's interest in and relationship with Post Office, you say at paragraph 18 of your statement that whilst BEIS had no legal responsibility for the Post Office under its Articles of Association, it had political responsibility for the company, which you say it took seriously. Is that right?
Yes.
And ministers took a broad view of its responsibilities for the Post Office given its social function.
Yes.
You describe the department's oversight of the Post Office as supervisory and advisory, with the department being heavily reliant on the reporting which came to it from the Post Office.
Yes.
On the question of the extent to which the department was able to intervene in Post Office matters, could we have on screen, please, paragraph 36 of Sir Alex's statement? It's page 10. Having set out the role of ministers in broad terms in the paragraphs above this, you say, it was never my understanding that BEIS was under a legal requirement which prevented ministers from becoming involved in Post Office Limited's operations. Post Office Limited's operational independence was a practice and not an immutable right. My own view is that Post Office Limited came to use its operational independence in a self-protective way. Ministers and BEIS officials were provided with carefully worded summaries without the benefit of sight of many of the key documents. The result was that over time, the reality of the situation as it concerned the Horizon IT system and sub-postmasters was obscured by Post Office Limited. Post Office Limited came to use its operational independence and legal arguments about privilege and confidentiality as a defence to certain decisions and to restrict the flow of information to ministers. You go on to explain that Pol's right to continue functioning at this level of operational independence was always contingent upon it fulfilling its responsibilities, both financial and social. Pol forfeited its claim to operational independence when it failed in its public duties, and ministers were entitled to intervene accordingly. And then at paragraph 38, you refer to the difficulty that by obscuring the reality of the situation, ministers and officials had a very limited picture of what had been happening within the Post Office, at least until the judgment of Mr. Justice Fraser was handed down in the Common Issues trial in March 2019. Had a more fulsome and honest information been provided to the department by Post Office Limited over the course of these events, I believe ministers would have intervened sooner and more decisively in Post Offices Limited operations. So from your, forgive me.
Could we just show paragraph 31 as well?
Of course, if we can go back to that, please. That's page 9.
I just wanted to show how the concept of operational independence was not only a kind of a convention or a practice, as I said there in the middle of that paragraph, but actually was the way in which a public corporation was meant to be treated, and that was defined in the Public Bodies Handbook, and I quote there the 2016 edition. So it says that is what a public corporation is. It's controlled by central government and has substantial day-to-day operating independence, so that it should be seen as an institutional unit separate from its parent department. So that's exactly how, it's often been mentioned about this concept of operating independence, but that's the bedrock, and you'll see in other documents such as the framework document that's fully recognised. The paragraphs that you've just drawn my attention to, which follow on from that, were saying that that was fine, if you like, when things are going well, but that neither ministers nor myself, the department as a whole, felt that that meant that we should be insulated from what was happening within the organisation, or that it meant it could do what it liked, so to speak. And in some of its operations, clearly it significantly failed, and that meant that ministers and myself had to become increasingly involved, and I think we had every right to do, and there was no legal bar to do so. Thank you.
Is it right that the reason for that greater involvement at the stage that it happened was because the picture the litigation revealed about the Post Office gave you increasing concern?
Yes.
And what was that concern?
I think even before we saw the judgment, the Common Issues judgment in March 2019 for Justice Fraser, which I think in the phrase used by the then Secretary of State, Greg Clark, was a seminal moment. That revealed a great deal about the way in which the Post Office operated its dealings with sub-postmasters and showed them to be, in effect, oppressive in many ways. So that was an incredible eye-opener for us. It was also very clear that the judge was very dissatisfied by the conduct of the litigation by the Post Office, by the way in which Post Office personnel had appeared as witnesses before the High Court, and all of that was kind of very considerable new information. I think even before that time, in the months of preparing for it, we'd been trying to get more information about what they saw to be the legal risks and their contingency plans and the potential implications of this, and we found that was very difficult to do so, and we had a lot of hard-fought negotiations over an information sharing protocol and so on to try and be able to find out what was happening. And then there was I think a kind of a carefully controlled flow of information to the department, which I think if we'd seen more, we would have seen, as I said later on in the statement, we would have seen that actually had no chance at all of success in the litigation, and they should have exited from it even earlier than they did.
The other reason you gave in your statement for greater involvement was that the department would need to be directly involved in bringing settlement. Can you just explain, please, why it was that the department needed to be directly involved in bringing settlement?
Yes, so I think that, first of all, the magnitude of the amount of sums, but also the implications of that, accepting wrongful practice effectively and trying to make good, would absolutely be a shareholder matter. I think technically the approval level, which Post Office Limited under their delegated authority was £50 million, and we anticipated it going beyond that, and indeed it was more than that. There's also a concept under managing public money, which is the main reference point for good accounting practice in government, that anything which is novel, contentious, or repercussive requires Treasury consent explicitly, which we had to obtain for that. So for all of those reasons, it was rightly, both by Post Office Limited and ourselves, seen as being a matter which the department would need to be involved in the decision making. But there was also, and again this comes up in later correspondence, I was very clear in my advice to the Secretary of State also that the department needed to be able to be a neutral party in relation to litigation so we could respond and deal with the fallout and the consequences and remediation. We shouldn't be a party to litigation, we needed to be above that in order to respond as necessary according to the outcome of the litigation.
In terms of your expectations of those working in a public corporation, is it right that you would expect them to act in a manner consistent with the Nolan principles?
Yes, indeed, and indeed in the letter of delegation, which again I've referred to the accountable person, it's very clear and it lists all the things that they're required to do by reference to managing public money, and includes, for example, treating your business partners with respect and things like that, acting always with integrity, such matters. So I think there should be no doubt about Post Office Limited as part of the public realm and its public responsibilities.
You made your expectation of this clear, it seems, in a meeting you had with Nick Reed on the 30th of September 2019. Mm-hmm. Could we have on screen, please, UKGI 30-18641? And we can see from the middle of page 1 that this is an email readout of your meeting sent on the 2nd of October. And going to page 3, please. Under Bay's expectations and immediate priorities, Alex set out his expectations of Nick as CEO of POL, including the Nolan principles and guidance on managing public money. Recognising Nick's lack of experience in this area, Alex stressed that he should lean on Bayes for this if ever unsure, especially for anything that is novel, contentious or repercussive. You were here setting this out in terms for Nick Reed, but more widely, during your tenure as permanent secretary, was it made clear to the Post Office senior executive and the board by the department that the organisation was expected to operate in accordance with the Nolan principles for standards in public life?
I can't remember any specific reference to it in documents, so and I haven't seen any in the ones the inquiry has shared to me. I think that when Paula Venables would have been appointed accountable officer by my predecessor, the letter of appointment, which I'm sure is pretty standardised when you become an accounting officer, would have said the same things that my letters when I appointed Nick Reed and indeed Al Cameron when he was interim chief executive before. So it would have been set out their public responsibilities there. I think I was making a particular point of it here with Nick Reed because unlike both of his predecessors who'd been a number of years in the organisation, which was a public corporation, Nick had been working in the private sector beforehand, and I was sort of, I suppose, trying to lead him through it and say it's a bit different, in the public, these are the things that you need to pay particular attention to.
Do you think there is a case for there being more extensive and wider guidance to the Post Office on the nature of those responsibilities?
It's possibly the case. I mean, I think that given all the things we know now about the shameful, disgraceful actions that the Post Office were engaged in, anything that the inquiry can recommend which will reinforce upon them the high standards required of them and their public duty, I'm sure will be welcome.
Did Nick Reed lean on the department as you had invited him to do if he was ever unsure?
Yes, in my time, and he was appointed in September 2019, and I finished, as we heard, at April 20. So in that 6.5 months, I had a number of interactions with Nick Reed. I found him to be bringing a fresh perspective. I found him to be very welcoming of advice and input. He seemed not to be over-identified with the post office's past, which was very necessary. After they had been resisting any need for settlement for a long period of time and bringing a number of ill-judged recusal and appeal attempts, he immediately saw, as indeed did their new general counsel, that had been a mistaken path and that they should not only try and bring about a financial settlement, but also set the post office itself on a path of cultural renewal, which we thought was very necessary. He introduced, with my encouragement, but I think on his own initiative as well, a rapid review of their culture. They brought in some external people to try and advise on that, to try and also to get advice on how they could repair the relations with the sub-postmasters. So in all of that, in my experience, Nick Reed behaved like a responsible chief executive, quickly trying to understand the expectations of the so-called parent department, but also the needs of stakeholders and trying to run the organisation and put it onto a better footing.
That document can come down now, thank you. I'd like to ask you, please, about some specific examples of matters which you consider the department should have been made aware of, but was not. You were briefed on the Horizon litigation in May 2018, is that right?
Yes.
Could we have that May 2018 briefing on screen, please? It's UKGI 408026.
And while that's being done, can I just ask, Sir Alex, was that the first time you were given a formal briefing on Horizon, or is this just an example that we're going to look at?
Thank you, Sir Wynne. I think that May was the first time I was given a briefing, and the timing of that is probably because that was the after a case management meeting had taken place in relation to the conduct of the so-called common issues litigation. So before that time, it wasn't known what how the whole case would be managed. At that point, I think they had a concept of how it would be managed, the timing, the processes, the issues. I think and I said, that's interesting. This is going to be a big deal. I need to know lots about it. I want a full briefing. This was the initial briefing. I said, that's good, but I need more. And then there was that process of slight negotiation between UKGI's lawyers and Post Office Limited's lawyers about how much information we could be given under what terms, the so-called information sharing protocol. But ultimately, that led up to a very detailed briefing, which we ended up getting in October, we being the minister responsible, Kelly Tolhurst, and myself from the Post Office legal team.
Thanks. Sorry, Ms. Price.
Not at all, sir. It's right to note that this is a draft of the briefing, so we have the date at the top, XX May 2018. And although we do not appear to have the final draft, you say that the content in the most recent May drafts are familiar to you, is that right?
Yes.
And you think that you were, in fact, given this briefing in May?
I expect so, yeah. Yeah.
Looking, please, to paragraph 27. Forgive me, 2 more pages. Here we have this. In terms of mitigating against legal and operational risks, Post Office Limited has summarised its past and ongoing measures in paragraphs 21 and 22 above. In addition to these, UKGI is aware from past discussions with Post Office Limited that Post Office Limited did the following. first appointed Deloitte in 2013 to look at the Horizon system to establish its veracity. Whilst this was a limited study due to the passage of time, at that time Post Office Limited informed us that no issues were found. Secondly, at Baroness Neville Rolfe's request, when she was the responsible biz minister, the then incoming Post Office Limited chair, Tim Parker, commissioned a new QC to investigate the matter when he joined Post Office Limited in October 2015. The initial findings satisfied the chair that Post Office Limited had taken the appropriate action at each stage. With the announcement of the group litigation in November 2015, the chair decided, following legal advice, not to conclude the investigation on the grounds that it could have impacted the court's consideration of the claims. And finally, POL has also investigated individual cases and at the time informed us that no systemic issues were found. Is it right that you did not receive a copy of the 2013 Deloitte report or the report of Jonathan Swift KCE?
Yes, it is, and indeed, it's interesting looking at that paragraph. It doesn't refer to any reports, indeed, it's almost been written. I'm sure it was written by Post Office Limited's lawyers at the time, so as not to attract interest. Nothing to see here. It doesn't refer to who the name of the QC we now know to be Jonathan Swift. And it refers to initial findings and appropriate action being taken. It doesn't say there's a report. It's actually a 66-page report with 8 recommendations in, but you wouldn't know it from that summary, and I didn't know it. I never saw that report until the inquiry showed it to me.
Before the inquiry showed you those documents, was your knowledge of them limited to what you were told in this briefing?
Yes. We got similar phrases in the October briefing.
In particular, looking at the statement in relation to the Swift investigation, the initial findings satisfied the chair that Post Office Limited had taken the appropriate action at each stage. What is your assessment of this statement, having now read the Swift report?
I think that's a very poor and inaccurate summary because the full report, which is before the inquiry, shows a lot of loose ends, a lot of limitations, but also has got 8 recommendations for further work not only on legal issues, but also technical issues with the operation of the Horizon system and accounting issues with the reconciliation of funds. So in no sense is that saying everything fine here, which is the impression given there. Is actually there are a lot of issues here which require ongoing attention and do point to some undoubted considerable weaknesses and failings on the Post Office's part. I get no sense of that from that description.
Is it right that you also had no knowledge of either the existence of either of the clerk advices?
Absolutely not. So you're referring there to advice which, again, the inquiry has shown to me from before the time that I joined the department, as indeed both these documents I joined in 2016. So these earlier points which point to, and I was absolutely amazed and shocked to read those because written by a criminal barrister or solicitor, I think, saying that the Post Office had knowingly continued to provide and employ an expert witness, even though the expert witness had chosen not to reveal evidence, share with the court evidence which undermined their own evidence, so effectively tainted evidence, which I think is a major failing under the criminal law. And furthermore, that Post Office had not fulfilled its obligations to keep a proper record of information relevant to those criminal investigations, and indeed had been involved in some cases in destroying that information. So I can hardly think of more serious information to have been to come to anyone's attention. But that was absolutely hidden from the department. We had no idea. If we had, we would have been absolutely shocked because it would have shown that obviously none of the criminal investigations were safe.
Going back, please, in this document to page 2, paragraph 7. You were given some information about Second Sight's investigation here. An independent firm of forensic accountants, Second Sight, were commissioned to examine the system for evidence of flaws. which could cause accounting discrepancies. Second Sight's initial report in June 2013 found no evidence of systemic flaws in Horizon. A final report in 2015 did find that in some cases Post Office Limited could have provided more training and support to some sub-postmasters, though Post Office disputes many of Second Sight's findings.
Again, I put that in the character of nothing to see here, and actually I have now read those reports, and they, again, that summary doesn't perhaps do full justice to them. I'm sure it was well intended, but the it says, this phrase, much used, found no evidence of systemic flaws in Horizon. Actually, Second Sight did have certain limitations to their own access, and they said that, and they said there were some discrepancies, and they'd like to do further work, and that work was curtailed. So I don't think it provides a very reassuring report, or at least not as reassuring as that summary would imply.
You were, though, told of the existence of 2 Second Sight reports here.
Correct, yes.
Did you ask to see either of them at that point?
I didn't at that time, and that's for a simple reason that the operation of the Horizon system was the second issue before the High Court. The overall case, civil litigation, was split into four pieces. We only got to 2 in the end, but the second one was looking at Horizon, and I knew that that was going to be a matter that was going to be subject to very, very close attention in the High Court with expert witnesses on both sides. So that was going to be a much fuller answer to the question than Second Sight's work had provided. And also, if the Post Office were in dispute with the findings of it, that didn't seem to have been like the final matter on it, whereas I was confident the High Court would get to the bottom of it.
That document can come down now, thank you. Is it right that following this briefing, later in May 2018, you asked to be briefed on the litigation by Post Office's General Counsel?
Yes.
Why did you make that request?
I'd been getting indirect summaries of this kind, and I wanted to have the chance, both for myself and for the Minister, to ask some questions directly, and also to have a fuller account. The Post Office was very quick always to claim kind of questions about legal privilege and so on. So, you get these very heavily edited pieces of information, and indeed elsewhere in the file of papers you've given to me, there's an example of UKGI lawyers, again, arguing with Post Office Limited lawyers where they were trying to draft the first section of advice, and great chunks of it had been taken out by Post Office lawyers, including things like the impact on Post Office Limited had been taken out of the brief. So there's a lot of rationing of information, and I was already impatient with that. It became more so, of course, of the months that followed, and wanted to have the chance to get as full a briefing as we possibly could, and to have a meeting on it with the elusive Post Office legal team.
So were you, by this point in May 2018, already concerned about information flow to the department in relation to the litigation?
That was the beginning of concern.
That briefing came in October 2018, is that right?
Yes, originally in September, but then it got rescheduled for October.
Although you described the briefing as extensive, you say you considered the section setting out the background to the litigation to be relatively short. Is that your view?
Yes.
Could we have the briefing on screen, please? It's POL 2031214. And going to the executive summary, actually, sorry, if we can just stay on that first page. We can see there, this is the briefing paper for the meeting on the 17th of October 2018 with Kelly Tolhurst and you. So this briefing came to both of you, is that right?
Yeah, also strictly confidential and subject to legal privilege, as it says.
Going to page 3, please. At paragraph 1.2 under the executive summary. Back a page, please. 1.2. What is the case about? The case represents the culmination of a series of campaigns by disaffected postmasters and others, including a number of MPs on both sides, who believed that Post Office wrongly attributed branch losses to those postmasters and that as a result they suffered financial and reputational harm. A theme of these campaigns is that flaws in Horizon, the in-branch point of sale system, were the cause of these losses. Going over the page again, please. 1.8. The number of claimants is identified here as 561. And then going to page 6, please, the section on background to the litigation. And this is the section that you describe in your statement as being relatively short. And at 2.2, there's this. In 2012, a small group of mostly former postmasters, under the banner of Justice for Sub-Postmasters Alliance, and with the support from some MPs, led by the then MP, now Lord James Arbuthnot, claimed Post Office's Horizon IT system had caused losses, shortfalls in physical cash against cash holdings recorded on Horizon, which they had to make good. In some cases, they had been prosecuted for these losses, usually for false accounting, theft, or both, while in other cases they claimed that it led to their contracts with Post Office being terminated, causing them financial loss and other personal harm, including bankruptcy, divorce, and emotional distress, including suicide. So you were told here that sub-postmasters had alleged that the IT system had caused losses which they had to make good. Mm-hmm. And this had led to some people being prosecuted for the offences listed there, mm-hmm. and the other consequences that are set out.
Yes, and in fact that's, I think from memory, the only half sentence in the whole briefing, which goes on for dozens, if not hundreds of pages, which actually in some way pays attention to the human impact of what had happened. It does say even there wrapped in a claim rather than a reality, but everything else in the litigation, when you in the briefing, when you look at the contingency plans, it talks, for example, of installing CCTV in postmaster offices. It doesn't really think about the impact on the people involved.
Did the nature of the allegations being described here mm-hmm. not cause you some alarm by their very nature?
Yes, but that wasn't new that these were the allegations. As I said, they've been around. I was briefed as soon as I joined the department on the fact that there was this litigation. The litigation had been joined in March 2016, 6 months before I joined the department. So the litigation was underway, and we understood that the heart of the litigation was people saying that Horizon gave false results, and therefore they'd been falsely prosecuted.
Did you understand when you read this briefing that it was the Post Office which had been doing the prosecuting?
Yes.
Had you been aware of that from the time you took up your post as permanent secretary?
Yes, and I said, what's happening now? The prosecution stopped, and the answer was yes, the prosecution stopped in 2015, over a year before I started. So that wasn't a live issue. The question was, how had they been done in the past, and had they been done justly or not? And that was the issues that was being looked at by the High Court. I was also briefed, it's again included in other documents, that the criminal cases review body were examining whether or not, I think around 30 or so cases had been referred to it at that time. So I was well aware of that. So both the criminal cases review body and the High Court were the main areas where these actions were being looked at that time.
Did you consider, when you read the briefing, mm-hmm. advising the responsible minister, Kelly Tolhurst, to consider meeting any of the MPs who were supporting the sub-postmasters or the sub-postmasters themselves to understand their position?
I don't remember giving that advice. I think that all the postal ministers at various times did meet with representatives of sub-postmasters, and so that was absolutely a part of their job. They also would have met with, there were a number of Westminster Hall debates and other things whenever they appeared in the Commons or indeed in the Lords. There were also debates about it. So they had quite a lot of interaction on this issue, and if I may say also that in my experience of elected ministers, that they always understand the role that post offices play. It's the nature of their constituencies, that they understand the local role of the post office, the support they're involved in. They would hear these stories, and so both Greg Clark and Kelly Tolhurst, who I worked with for 3 years, were very understanding and sympathetic of these issues and keen to make sure they would be resolved satisfactorily.
But that isn't something you recall discussing with Kelly Tolhurst after this briefing, or in relation to the issues raised by the litigation?
She would already have had contact with the sub-postmasters and with the various MPs who had, who took up their cause. So it wasn't a consequence of this. I think what we did discuss was what the chances of success were. And in the same briefing, you can see there's a lot of statements there that from the legal advisors saying that they had the stronger part of the case, and that on the issues which were the most significant, they were particularly confident that they would do well. They also, I think, described the issues very much in terms of very precise kind of, legalistic issues about the interpretation of the contractual obligations and about the burden of proof in prosecutions and things. So they were called common issues because they were seen as kind of, legal issues which needed to be resolved in the court. Both Kelly Tolhurst and myself, our instincts were that this was not going to go as well as the Post Office expected. And that's why, and it's recorded in another document, I'm asking even at that time, shouldn't you be settling? And we'd had experience in other piece of litigation elsewhere in the department where a settlement had been necessary and had brought it to an end. And we were concerned that this would be going on for a long time, and that the Post Office was digging themselves in more and more and should be open to trying to, to a mediated solution.
At paragraph 2.3 below, there is reference again to Second Sight. Mm-hmm. And Second Sight issued a report in July 2013 which concluded there was no evidence of system-wide systemic problems with the Horizon software, but identified some areas where Post Office could have done more to support individual postmasters. It was Kelly Tolhurst's evidence to the inquiry that she understood from this briefing that there may have been occasional bugs or errors in the system affecting individual sub-postmasters, but there was no serious problem with the Horizon system. Was that also your understanding?
The Post Office had maintained for years that there were no problems with Horizon, and they used these stock phrases. Is very similar to the phrase given in the briefing you put up earlier about May, referring to Second Sight and sort of praying their report in aid to say there was no evidence of system-wide problems with the Horizon software. And it says there, done more to support individual postmasters. I think in the previous one it was more support and training. So it was a sense in which it was a training issue rather than a fault in the system, and that's what the Post Office maintained throughout until it was shown not to be the case.
But specifically on Kelly Tolhurst's understanding, which she had after reading this briefing, that there may have been occasional bugs or errors in the system affecting individual sub-postmasters. Did you also understand that?
I don't remember that point arising, but might have.
At paragraph 2.11 of the briefing, please. There is this. In recent years, the focus of the complaints by postmasters had expanded from issues with the Horizon IT system to the alleged unfairness of the contract between Post Office and postmasters, despite significant lobbying by the JFSA of Parliament and through the media. Post Office's position has not altered and considers that these disputes are now best resolved through the courts. Did you understand at the time that the complaint from sub-postmasters about the fairness of the contract was that they were being asked to make good apparent shortfalls, even where the Post Office could not prove the loss was due to the sub-postmaster's own negligence, carelessness or error?
Yes, I think that the intricacies of this about the nature of contract law and where the duty lies, and that was something that was brought out in that briefing. I think, again, the tone of that paragraph is lacking. I think the alleged unfairness in inverted commas, and the sense in which the postmaster's case is kind of is drifting along, whereas the post office is kind of resolute and unaltered, and I think there is probably speaks to the whole frame of mind the post office had about their position, that they were right and everybody else was wrong, whereas it turned out it was the opposite of the case.
The arguments in the litigation about this were in fact addressed in this briefing document later on.
Right.
And if we can go to page 37, please.
Mm-hmm.
This is the contingency planning for high impact areas in the scope of common issues. So that is areas which were defined as having a significant adverse impact on the business if the implied terms of the contract were to go against the post office. Did you read the contingency planning section of the briefing?
Possibly. There's obviously a lot of detail here, and it was a 1 hour meeting, but
the issue is set out in the left column.
yeah.
And in relation to shortfalls, the implied term for which the claimant sub-postmasters were arguing for was set out. The post office would cooperate trying to identify the possible or likely causes of any shortfalls without any input from the sub-postmasters, and or work out whether or not there was any shortfall by carrying out a formal investigation, and prove as a result of the investigation that the shortfall was properly attributed to the sub-postmaster under the contract. Mm-hmm. And going over the page, we see the effect of what was being sought by the sub-postmasters by that implied term. And post office would not the impact there. Losing this point would make it very difficult for post office to recover losses without significant effort and details investigation into every loss in every branch. It also has the effect of shifting the burden of proof onto post office to show the root cause of the loss. In many cases, this will be impossible to discharge. Does that cause you any concern at all, looking at that?
I mean, that seems to be an accurate description of the issues that were before the court. I think the hearings began the month after that, and obviously they looked at that very closely. It's interesting that the impact on the post office, that section had previously been removed from the briefing by the post office lawyers given to me, so they obviously saw it as a sensitive issue that they were a bit slow in wanting to share, but at this point they did so. I think that I understood the legal point there about the burden of proof. I didn't know what the actuality of it was, but not being an expert on contract law, and indeed experts on contract law were subsequently consulted and themselves found themselves to have got it wrong in the view of the High Court and the Appeal Court. So obviously some real deep legal issues there. I think I did understand that it made a huge difference to the sense of who had the responsibility for it, and therefore why the sub-postmasters felt so strongly about it. And indeed I recall that the settlement, which came over a year later, December 2019, as well as often talked about as a financial settlement, has actually got some very important terms to address this very issue, and has got a whole schedule devoted to changing the way the post office actually sets about establishing loss, and those commitments were entered into formally through that settlement process. So that was obviously a key issue for the sub-postmasters, which indeed they got resolution of.
The default position here was that it was for the postmasters to prove that an apparent loss was not caused by their own negligence, carelessness, or error. Did that feel wrong to you at all at the time?
It did seem surprising, but again, this wasn't happening in my time. The postmaster prosecutions had ended a year before I started, so this was a historic issue which was going to be looked at by the High Court, who would rule on it definitively.
That document can come down now, thank you. Could we have on screen, please, paragraph 129 of Sir Alex's statement? That's page 34. Here you give your reflections on this briefing, and you say that the document was not sufficient for me to understand the issues properly. I now know that a number of external reports, together with legal advice on those reports, were vital to the history of these issues. In my view, ministers and I should have been briefed on the contents of the Deloitte reports and Second Sight's reports. We should have been provided with copies of the Clark advices, Linklater's advice, and the Swift review. We should have been provided with the history on the existence of bugs, errors, or defects with Horizon, and the steps taken to investigate them, which were extensive, and their conclusions. Those matters were highly material to achieving justice for the sub-postmasters, and in properly understanding that Post Office Limited's prospects of success in this litigation were, in fact, always poor. Furthermore, we should have been made aware that there were important remedial steps recommended by Jonathan Swift QC that had not been actioned, indeed had not even been shared with the board. In terms of reflections on your own actions at this stage, do you think you could have been more probing about the litigation, given what we've just looked at in the briefing on what you were told?
I don't think we could have asked for documents, the existence of which we didn't know.
What about the Second Sight reports?
The Second Sight reports, they were mentioned and we could have looked at those. I've explained already that they were the way they were described were things which had provided a degree of reassurance, but also that the Post Office wasn't, fully in agreement with them. And they were describing the operation of the Horizon system, which was being looked at by the High Court. So I didn't think that was particularly important. I was more concerned here with the Deloitte report, because that does talk about bugs and remote access and all of that. So that obviously seems to be speaking to a difference between what the Post Office has been saying in a number of public statements and the actuality. That also was looked at, particularly in the Swift review. Again, lots of information there about bugs and errors and defects and weak points in the Post Office proceedings, and a whole load of recommendations for further action. And I've said already, most shockingly, the Clark advices, which I only saw when the inquiry, showed them to me in the summer, this summer, 24, which showed that, those criminal prosecutions were basically unsound, and I think that is really a shocking thing, absolutely shocking, and there's no hint of those. The first I saw was in 2024, so people in the Post Office must have known that advice was given to the Post Office. People in the Post Office must have been aware about destruction of documents and tainted evidence, but no hint of that was given to the department. If we had seen that, I think we would have taken, much more significant actions, and indeed, as I point out there, we'd have seen that they were going to lose for sure in the civil litigation, which they ended up losing, but we wasted another year and a lot of money and a lot of distress in the meantime. And even more importantly, all those criminal investigations were left to stand for a long, considerable further period. I think the Criminal Cases Review Board didn't complete its work until I think 2020, and I think the overturning of those by the appeal court was 2 more years, and finally legislation was passed in 23. So it's a very long passage of time, but we could have, cut short all of that if there had been a fuller furnishing of the reality of the information, rather than this careful economizing with the actuality.
Sir, I wonder if that might be a convenient moment for the afternoon break.
I think it would, Ms. Price, yeah. So what time shall we resume?
If we could come back at past, that would help us this afternoon.
All right, fine.
Thank you, sir. Good afternoon, sir.
Good afternoon.
Sir Alex, if we could go please to page 31 of the statement, that's paragraph 115, and if we can have that on screen, please. And you say here, my impression all through 2018 was that Post Office Limited's position in respect of providing Bayes officials and ministers with information regarding the litigation was on a need-to-know basis, and indeed that there was an institutionalised wariness about what the department should be told. Is this an impression you formed at the time, or is this something you developed later with the benefit of later knowledge?
I would say both. I think at the time I was already conscious about the rationing of information, because when I asked to see the documents, there was a delay, there was this negotiation over the information sharing protocol. When it was finally agreed after a lot of negotiation, I then said it wasn't acceptable because it said with this information I couldn't talk to anybody else about it, and I said I might need to, I obviously had responsibilities to Parliament, across government, I might talk to the Treasury, to Cabinet Office, etc. So that had to be changed as well. So there was just a kind of a wariness. I also began to see these stock phrases kept appearing in the briefing, and I began to think that they were, designed not to kind of really invite one in and to show the full reality. So that was an impression that I already began to feel in 2018, and you can see that in other correspondence over getting access to the full briefing. I think it's definitely been reinforced now by the experience of the inquiry, showing me documents which the Post Office had, which they chose not to reveal to the department, such as the Swift report, the Clark advice, and other things we were looking at a moment ago.
Looking back, do you think that there is anything more you could have done to investigate the true position in terms of what the Post Office knew?
I think that we became increasingly assertive as we became more concerned. I think that, there's certainly a debate to be was had in the late spring of 2019 as to whether we should make wholesale changes in the Post Office board, because that was after the Common Issues judgment and after they'd made their misguided recusal attempt. So not in 2018, but in 2019 we did look at even more interventions. We did make quite a few interventions at that time. We obviously did change the chief executive, the general counsel was also changed, their legal advisors were changed. There's quite a lot of change happened there. Could we have brought about change more quickly? I felt there was an opportunity to settle early, and there's a lot of evidence of my pressing for that. The Post Office themselves were sure that they were right, and they needed, as it turned out, to lose 3 times and change their leadership before they came to see that they were wrong.
You describe in your statement Post Office not coming across as wanting government involvement. What do you think lay behind this?
I think, we described as a parent department. Every child probably wants some greater degree of independence. And I can see from documents, again, you've shown to me meetings with the chair. The chair is often saying, could you lower the level of oversight? Could you have less intrusive inquiries? Why do we have to provide this information? So they were trying to treating that as a burden rather than as both a necessary form of accountability and as a source of guidance and advice. So I think that did rather speak to the Post Office culture at that time. I don't know how it is today, but that they did tend to be kind of a little bit self-absorbed and defensive, and seeing the outside world as a bit threatening. And unfortunately, we were part of the outside world from their perspective, and that was why I think they tended to ration the supply of information to us and to be a little bit resentful rather than welcoming about our oversight.
Was this not a red flag to you, indicating a need to look more closely at the functioning of the relationship between the business and the shareholder?
Yes, and that's why in 2018, it started in January 2018, we had a first draft of the new framework agreement, and one of the changes in that was to try and institutionalize the expected roles, the flow of information as part of that. It took a long time to actually get that agreed with the Post Office, but that was exactly with that purpose in mind.
Do you think this was an indicator that the Post Office did not appreciate the significance of the public aspect to Post Office?
Yes, I think that's true. I think it's correct to say that they weren't a typical public body because they were a retail business, and a lot of their thoughts and minds necessarily were on what it takes to run a business, logistically and in terms of staff and product offers and customers and all of that, and it's a complex enough business to run. So I think it's right that they were thinking about those things. I think sometimes that they underthought or didn't fully understand that all this was still being done within the public realm, that they had a public duty, and that fundamentally the reason there was a post office is because post offices provide a vital social as well as economic purpose. And oftentimes, and you can see in my letters and meetings with them, I'm saying, don't forget about the social purpose. That's what it's there for. This is people who depend on the post offices for access to benefits and passports and identity information and pensions and tax credits and what have you. And that's really why those so-called services of general and economic interest, or it's a bit of jargon, but that's what they're called. That's what the postal services were providing, and that's why we had them. And so I think that the interest in business and making a profit and all of that was okay, but wasn't sufficient, and the public responsibility was there.
Moving, please, to the role played by UKGI.
Mm-hmm.
You describe UKGI as being responsible for oversight of Post Office Limited in respect of both governance and policy when you were appointed Permanent Secretary.
Correct.
By early 2018, you say you were considering the new shareholder relationship framework document, which we've touched on already. What made you think this was necessary over and above the concerns about information sharing? Was there anything structural that made you think it was necessary?
Yes, there was, and I think, and let me try and set that up as help with the inquiry. So UKGI, its predecessor body, Shareholder Executive, had a high level of professional expertise, a lot of people with background in managing corporate transactions. They had people who were kind of experts, if you like, in governance, people who compared doing these different roles across different parts of the public realm. So that is the positive and useful part of it. However, they actually didn't have as much experience of working with ministers, and some of the finer judgments about political preferences and requirements, I think, was a bit harder for UKGI staff to pick up on. When in the regime I inherited, everything was done through UKGI, I think I found increasingly that, given our concerns about the department, given the high level and justifiably high level of ministerial interest, given this was becoming more and more a political issue, that we needed to have some direct departmental input to that. So we established in 2018 a post office policy unit within the department, which worked in parallel with UKGI. I should say UKGI in no way resisted this. They themselves felt that it was good to have a strong policy partner, and that UKGI would provide the kind of shareholder expertise. So we moved from, if you like, a one-engine to a two-engine operation from that point onwards. That's what we have today as well. It's persisted.
The final version was agreed in mid-December 2019, you say in your statement. Is that right?
Yes.
Can you help with why it took so long to reach agreement on it?
I guess it probably wasn't seen as the absolute top priority, because people were acting on, on the basis that we had a kind of these different responsibilities, and in a way the final signed agreement was, if you like, the codification of that. Also, the drafts were in circulation, so everyone knew the roles that people were expecting to be played within it. I don't know whether there was also kind of low-level negotiations or friction between the teams. I don't know, I wasn't part of that. Every so often I would say, where are we with the framework agreement? They say, oh, it's coming along, we're almost there, you know, and in the end it was there. And we hadn't had one before, so that was a necessary and important improvement in governing the relations between, it's really a tripartite arrangement between UKGI, BEIS and Post Office Limited.
When you took up your post as Permanent Secretary, did you consider the avenues for reporting to ministers on Post Office issues to have been effective?
I think when I first started, I could see that I think there were 6 different parts of our 40-odd public arm's length bodies, partner organisations. I think 6 of those were managed on the department's behalf by UKGI. And they had a lot of expertise. They did a very good job across that overall. I think the Post Office, if you like, moved from being seen as something where the business skills available to UKGI and their experience in kind of corporate finance matters and, you know, investment returns and all of that, that became, relatively speaking, less important than these much wider ramifications about, was the Post Office actually fulfilling its fundamental purpose? Was the Post Office actually run by competent and honest people? And the much more fundamental type questions which necessarily ministers will want to be advised on directly.
Could we have on screen, please, paragraph 248 of Sir Alex's statement? That's page 65. You say UKGI plays an important and valuable role across government. UKGI officials dealing with Post Office Limited were under considerable pressure throughout my tenure. I never had reason to doubt their integrity, work rate, or professional skill. At times, we reached different judgments on certain matters, notably the bonuses issue, and we'll come on to that. I think they also struggled at times to reconcile the tension between identifying with Post Office Limited and standing at one remove to challenge Post Office Limited. Pausing there, is this an impression you formed at the time you were Permanent Secretary? And if so, at what point into your tenure?
Yes, I mean, I think on the whole, we received very good advice and service from UKGI, and I stand by what I say there about their integrity and professionalism. I think that because they were on the board of Post Office Limited, and as a member of a board, I think they identified with the board, they felt they were directors, they had responsibilities there. That probably sometimes gave them almost too much, you know, information and awareness of the interests of Post Office Limited. And they were required by their role to also sometimes stand back from that and say, okay, well, that's all very well, but, are you stuck in a kind of a particular mindset or group think here about particular pieces of litigation? Have you really looked at it from the other perspective? You know, is it a possibility, for example, that contrary to the Post Office's long-maintained position that they were actually wrong about Horizon, and that and if that was the case, that there had been miscarriages of justice there. And so there was a kind of a myopia which I think was there within Post Office Limited at that time, and I think it would have been very difficult for UKGI and their succession of shareholder representatives on the board to challenge that. But I think that was part of what they needed to try and do, difficult as it is. And also, as I go on to say there, as the kind of supervising body, they needed also to be able to sometimes test the version of things they were given. And there's an awful lot of stock phrases, and you can see where whole chunks of text are kind of lifted from one document to another, from supplied by Post Office Limited to UKGI and then given to the department on that basis. And very understandable they should do that, and also to try and, if you like, smooth things along and suggest things are going quite well. But I think the unintentional effect of that, as I go on to say there, is it probably preserved the status quo for a bit longer than would have been the case otherwise, and postponed the crisis. And a crisis was necessary and happened in 2019, and actually that brought, complete changes in the leadership of the Post Office, the beginning of compensation recovery and cultural renewal.
Was this something which those at UKGI struggled with across the board, or were there particular individuals who struggled with it more?
I mean, UKGI is an organisation of about 100 people, and they work closely.
I mean, forgive me, those working on post office.
Yes, I think there's about 4 working post office, but if you look at other papers given to the inquiry, you could see that there's a lot of discussion within UKGI, support from the chief executive, deputy chief executive. You can see board meetings, post offices constantly being looked at as an item. So it's not only the individuals working there, there's also the wider organisation trying to give support. As part of that, I thought that they were extremely competent, the people who worked on the post office account, so to speak. I think at times, at the margins, they found it quite difficult to judge the political issues. And you said you want to come on to the bonuses one, that's an example of it. And I think at times that ability to try and be a member of the board, but also to be sort of a little other compared to the other members of the board and bring a genuine challenge, I think, again, that could have been even stronger at some points, but undoubtedly a difficult role to perform, and I don't envy them all.
But you do identify this as potentially a contributory factor to there being a delay.
Yes, particularly in the way the briefings, those phrases, and you've shown them up beforehand, again, stock phrases, kind of the way in which the Post Office legal team gave material to UKGI, which they didn't themselves challenge. They relied on those representations, but they could have said, hang on, so is there a report? Can we see a report here? And they didn't do that, so they might have perhaps been more pressing on our behalf. But that is with the benefit of hindsight and knowing what I know now, which I didn't know at the time.
You make some proposals for accountability mechanisms in your statement at paragraph 255. Could we go to that, please? It's page 66. And you say, to my mind, there are other ways by which accountability of ALBs could be improved across the spectrum. It starts with openness and pattern recognition. If concerns are raised, there should be formal and publicly accessible means of reporting and tracking those concerns. That mechanism could be overseen by an independent committee that has mandatory reporting responsibilities to the board, as well as the authority to write to the Secretary of State annually with any concerns. There could also be obligations to report periodically to Parliament. As a basic principle, where an ALB has failed in the trust that the public places in it, this calls for more frequent and more intrusive government scrutiny. In your view, should those accountability mechanisms enhance existing structures, or should this, i.e., be in addition to them, or replace them?
I think in a perfect world you wouldn't need to have this because it obviously adds an extra layer, and every additional layer creates scope for friction, cost, and risk with that. However, in the particular circumstances here where the Post Office Board has failed in its oversight responsibilities, which clearly lie with the Post Office Board, and the management executive being part of that, their internal legal teams over many years, have failed to provide, effective service, then that has caused to obviously a terrific breakdown of trust, not only with the sub-postmasters, but the wider public. So in effect, I'm saying here that special measures are required because of the failings the organisation has gone through. Now, that was my judgment based on my knowledge of working with the organisation, which I left as my role in relation to it in 2020. So I don't know what's happened since, and it may be now that the board works much better and the executive has rebuilt trust with the sub-postmaster. Other people can speak to that. You've got other evidence, I'm sure, on it. But that was why I was thinking about some kind of external oversight committee as a potential tool for doing that. But it's not a straightforward matter, because then you have run the risk of undermining the board and its own responsibilities, and you've got sort of, guards for guards for guards, and that itself, can obscure the underlying reality.
Turning please to consideration given to settlement of the litigation. You've touched on this already.
Yep.
Can we have on screen please paragraph 131 of the statement? And you refer here to the Articles of Association requiring approval for any spend over 50 million. We've already referred to that. The requirements of managing public money. And you say it seemed possible that ongoing investment would be needed if there was to be wholesale change required to the sub-postmaster contractual relationship with Post Office and or the Horizon system. And that lay behind your invitation for a representative of HMT to attend the 17th of October meeting, because you saw it as the main opportunity before the trial starts to get all of the key stakeholders together to agree a common approach, including discussing the impact on Post Office Limited's financial position, the issue of settlement, and Post Office's approach more generally to mitigate against the risks posed. What was your view after that meeting of the 17th of October? Was it the 18th of October? That October meeting, on the adequacy of the consideration which had been given by the Post Office to settlement?
I think their view, and it's actually set out in the papers, both in the briefing and in the write-up from it, was that settlement couldn't be achieved because they were complex sort of legal contractual issues which didn't lend themselves to a kind of a settlement type of solution. They also, were quick to point out that, by no means all sub-postmasters were party to the litigation, so there would be, it wouldn't bring finality or a complete resolution. On the whole, I think they were mainly saying, it's too difficult, we can't do it now. I was saying, you're in a hole, you're still digging, so that was the area of debate.
You say in your statement that you also raised concerns about settlement in early 2019. Mm-hmm. What were your concerns and how did you seek to address them at that stage?
I sort of kept on at the Post Office about settlement, and you could see lots of other internal documents they have. As there he goes again, kind of Alex Chisholm's trying to get us to settle. At the end of it, when they brought in new management, they said, I could see a note from Ben Folk to Nick Reed saying, actually we should have settled this a long time ago, that was a big mistake, and then, would all have been a much better. So that clearly was right, but it did take them 2 years to recognise that.
You describe your disappointment at paragraph 199 of your statement, that it took that length of time for the leadership to recognise the importance of settlement. And you also refer to disappointment that it required change of almost the entire legal team to get away from the groupthink. Why do you think there was such resistance to proper consideration of settlement to that point?
I think it was a continuation. It's an interpretation, so I can't say for sure, but in my mind it's a continuation of this quite embedded view that the Post Office is right, the Horizon system is correct in all possible respects, and the kind of the errors are user errors within the postmaster community, and that you see that from all of that documents, a kind of sense of we're right and other people are wrong. And I think it was a kind of the Common Issues judgment in March 2019 was a sort of a substantial blow to that point of view, but actually required, unfortunately, further blows both in the judgment from the appeal court and recusal and in the appeal itself, substantive appeal, and furthermore in the second issues, which was the Horizon issues. So those four, they lost 4 times in a row, and at that point, finally, they were prepared to accept that they were wrong. And even that, as I said, was partly because they had a new chief executive, new legal advisors, not just a new general counsel, new solicitors, new external counsels. They had to change the whole lot of them. And I suspect, I don't know, again, that a lot of the internal advice was very much left to the legal team, and the legal team have been providing that advice for a long period of time, and were unable to allow for the possibility that they'd been misguided in that advice for a very long period of time.
Coming, please, to the recusal application. Could we have on screen, please, paragraph 152 of Sir Alex's statement? That's page 40. And here you say this. Bayes was unsupportive of the recusal attempt, deeming it unlikely to succeed and too likely to aggravate the situation and prolong the litigation process, which we saw as the only means by then available of resolving the dispute definitively and to achieving a just solution. Greg Clark, Kelly Tolhurst and I all expressed ourselves in our own way, but clearly all had real reservations about the recusal. Then at 153, you add that you thought it was the wrong move strategically and presentationally, as well as on the substance. At paragraph 156 over the page, you say it was also clear that the Department and UKGI took the view that the decision was for Post Office Limited as the defendant in the litigation and accepted that it should not do a volte-face on its long-standing and well-based position that Bayes was not a party to nor controlling the litigation. And you go on to deal with the discussions with Mr. Cooper, and towards the bottom of that paragraph. You say, I therefore said to Mr. Cooper that the department should maintain its clearly distinct and detached position so that it is free and credible for dealing with the consequences as they unfold. Ministers may want to show appropriate concern about the criticism and may express a desire for Post Office Limited to act appropriately, but should not comment substantively in ongoing litigation in which the department has a clear interest but no direct involvement. And you go on to deal with Mr. Watson's reply, asking whether you were agreed that we should not try to engineer a position whereby if the board decided to proceed with recusal, the minister is given a chance to object. You agreed that we should not so engineer a position that would make the department into a directing force in the litigation, which is neither correct nor prudent. Do I understand your written evidence correctly in being that although the department did not want to direct the Post Office's decision on the recusal application, you understood that the department's view on the application would be communicated to the Post Office board?
Yes, and indeed I, wrote. I think the news came through of that recusal about 7 o'clock on a Monday evening, and by 11 o'clock that evening I'd written a memo to Tom Cooper setting out my views at some depth, and also given a version of that to the Secretary of State and Kelly Tolhurst. And the decision was the next morning. That's why we were working late into the evening. So it's all written up at the time. You can see the documents.
Going to paragraph 163, please. You say, I'm aware now that Tom Cooper was advised to recuse himself from the meeting. I do not recall being aware of this discussion at the time, and I was not asked then for my view as to whether Mr. Cooper should absent himself from the decision. You say the decision did not, however, inhibit Mr. Cooper from conveying the department's views, and Bayes expected him to do so. I expected that Mr. Cooper would participate in the discussion, and in doing so relay the department's objections, as indicated in Stephen Clark, UKGI's email, dated the 19th of March. Your understanding from listening to the evidence given by Tom Cooper to the inquiry was that he did not participate in any discussion with the board regarding the recusal application, as he'd interpreted our correspondence as a clear instruction to stay out of this thing. What do you say to that, to Mr. Cooper's interpretation of your correspondence?
Yes, so I think it's absolutely the case, first of all, that we didn't think that ministers should take a decision which should probably be taken by the Post Office Limited Board. We were the department responsible for correct corporate governance. Everything else, the responsibility clearly was with the Post Office Board, so we shouldn't sort of secretly take their decision for them or take it on, and there were all kinds of negative consequences from that. So that's the first part. Secondly, I'm pretty sure I didn't know, and as I said, not aware that I knew that he was advised to recuse himself from the meeting. I've seen some of the legal chain thereafter, on that now, but which I didn't see at the time, wasn't copied to me. Seems to have been based partly in a sense that, if a government official was part of a recusal, it might show a lack of deference to judiciary, which I think it's an argument. It's probably a bit of a stretch, maybe a super cautious interpretation. I think maybe, notwithstanding that, people said, okay, well, don't be a part of the decision, but you should certainly be part of the discussion. I have seen again that email chain from UKGI lawyers and Bayes lawyers saying, yeah, you can make representations, you can make people aware of the department's views, but don't take the decision itself. I'm a bit unclear, even now from the evidence, what party did play in the discussion. I have seen the email from Tom back to the department reporting on the discussion, so he was clearly in it, but it's not a verbatim he said, we said type thing. It's just, this is a decision we had. It did say that in the discussion they had gone through very carefully the legal advice, the downsides, the issues, etc. So there clearly was a full discussion on it, but I don't know what Tom himself said as part of that discussion, though.
You attribute the fact that the department's view was not, at least expressly, communicated to the board to a failure of communication or interpretation between Bayes and UKGI at that next paragraph. Given the apparent strength of the department's view that the application was unwise, why did you not yourself approach the board to provide the department's views?
Well, I never attended the Post Office board, wasn't a member of it. We had a shareholder representative. That was our means for conveying the views of the department. So I had no reason not to have confidence in that representative, a very, very professional, capable person to be able to do that. So, and I didn't think there was any real doubt about our view because I'd written a 2-page memo and given it to him the evening before. So.
It was Kelly Tolhurst's evidence to the inquiry that she had understood that you were going to speak to the board, or if not that, it was left with you. Are you aware of that evidence?
Yeah, she's probably referring to the fact that I was looking at the issue and wrote that memo to her and to Greg Clark with my views, but those same views were communicated in writing to Tom Cooper as our representative.
Kelly Tolhurst had serious concerns about the recusal application. Would you agree? Do you recall that from the time?
Yeah, she was concerned about it. We all were concerned about it. We all thought it was going to make a bad thing worse, and it was going to, as I said in the advice, it was going to kind of confirm in the mind not just of the judge but the wider public that the Post Office was in denial here, and that everybody else was wrong rather than itself failing. So we were very concerned about that, and also that the same judge would then be sitting for 3 more hearings in this kind of further enraged state. So, it wasn't going to be tactically good, but also reputationally poor. She was definitely part of that. Equally, both Kelly Tolhurst and Greg Clark accepted the view, both from myself, but also departmental lawyers, that you could disapprove of something and convey your concerns and say, have you thought through all the downsides? Have you thought through this? Have you thought through that? But that we should not ourselves take the Post Office's decision for them.
Did she speak to you about the department taking a harder line, that is, shutting down the recusal application altogether?
She accepted the advice, and there's a readout from her office confirming this in documents you have, that we shouldn't take the decision for them, and we shouldn't put in place a second stage whereby they decide something and then we decide it for them or undecide it. We thought that was both legally incorrect but also unwise, because it would mean that thereafter it would effectively become our litigation, which we didn't wish it to be. It was Post Office that was defending their own track record, and we wanted Post Office to take responsibility for that and deal with the consequences, both financial and organisational, that would come from the outcome of that judgment. We wanted, as you've read before, to be outside of the fray, to be standing above it, to be able to respond as necessary, and not to become a party to litigation ourselves.
Did Ms Tolhurst express any view on the need for the Post Office Limited Board to be spoken to before the application proceeded? Did she give an instruction to anyone to that effect?
No, I think she had a conversation herself with the chair on the Sunday, I think. At that stage, the chair was expecting there not to be a recusal attempt. I think the legal advice from two different QCs at that time and from a former president of the Supreme Court arrived on the Monday, or at least was shared and distributed on the Monday. Everyone rushes around reading this advice and updating their thinking. That's when I wrote my memo saying it's going to have all these disadvantageous effects, but it's not wrong in itself, and we shouldn't make the decision for them. And they took the decision on the Tuesday morning. Ministers were advised on Monday and accepted that they shouldn't undo the decision or try and take it themselves. So that's the sequence that we had, and it's clear that ministers accepted that advice, which is why they acted as they did.
Would you accept that for whatever the reason for Mr. Cooper interpreting an instruction to recuse himself, that seems to have led to a failure to make the views of the shareholder or the minister known clearly to the Post Office?
It seems to be the case. Again, the record is not very complete about the fullness of that discussion. I wasn't a party to it myself, and I know the inquiry has already heard from the people who were part of that discussion, so they could speak to it better than I could myself. I have received the email from Tom Cooper after the discussion, which does, point to some of the downsides being fully discussed and the independent advice they were given, etc. So there obviously was a proper discussion about it and properly advised. They obviously reached a different conclusion to the one that we had reached, but that was their error.
Was there any sense in which a political interest was in operation here, in reserving responsibility for conduct of this litigation squarely with the Post Office?
A political interest in the sense that, Craig Clark as Secretary of State, rightly saw himself as kind of like representing the public interest. He didn't side particularly with the Post Office. Indeed, probably his sympathies more naturally with the sub-postmasters. So we waited to see what the outcome would be from the High Court and wanted to be there ready to respond as fully and effectively as possible. So I would say, kind of interested but neutral is the stance that we took.
After the recusal application had been unsuccessful, was the department more willing to be interventionist in their approach?
Yes, and indeed, at that time, Kelly Tolhurst, for one, was very, concerned she'd begun to lose confidence. I'm afraid she began to lose confidence in UKGI's representative at that time. I think she used a language around going native or something like that, identifying too close to the Post Office. She felt the Post Office themselves had become, economical with the sharing of information. And, she said that, she said that she thought that the chair should consider his own position. At that time, the chief executive had just stepped down, if you remember, and they were just in the process of trying to appoint an interim chief executive, Al Cameron. We then had a meeting, not only with her, but with the Secretary of State and other officials in the department, at which we considered a range of potential interventions. I think it got up to 11, and effectively we took the first 8 of those. We didn't at that time choose to change the chair. We did. It probably reinforced in her mind and mine that rather than cementing the interim chief executive, who had been the CFOO since January 2015, it would be better to look outside the organisation to find somebody who would bring a fresh perspective and, so to speak, a clean pair of hands. So that, I think, was one of the takeaways that we had from the whole experience. We became more suspicious and less trusting of the Post Office, sadly, and more intent on bringing about changes there, firstly with the chief executive, then with I mentioned the general counsel, then with all their external advisors, and more insistent that they should bring about a settlement, which indeed they did, and that settlement should be as definitive and comprehensive as possible and should address cultural change within the post office and a renewal of their relations with sub-postmasters, which had obviously, grown into considerable deficit.
If you had known the full picture from the post office, that is, you'd been cited on all the information you say now you should have been, would you have advised the minister to sack the entire board, to adopt your expression from your statement, the option being considered in June 2019?
We looked at that. I think it's possible. I know that ministers, particularly Kelly Tolhurst, sort of felt so frustrated, disappointed with the outcome that, a sense of kind of like, could we hold these people, accountable, was, absolutely one of the things that the questions that she was asking. I think when we looked at it a bit more and thought about it some more, we also felt, well, hang on, who are these people, in the sense that you had an interim chief executive and then later a new one who come from outside. Most of the board members have been appointed in the last 2 years, and indeed I think that board renewal process continued over the next year. So if we had chosen to change the whole board, we'd have got rid of, so to speak, some of the people we just hired to bring about change, and also we wouldn't really have had a body to then oversee that change, which is what you would obviously be necessary. So I think we changed quite a lot in the chief executive and the general counsel, and we tightened up the oversight that was applied to them and put in place a new framework agreement and strongly encouraged them to settle in the way that they did. So I think all of those actions came from it. It's possible that if they had known then, ministers, that there was a very big report, the Swift report, which had been withheld from the scrutiny of the board, I think they would have taken a very dim view of that, as would I. That might have tipped in favour of changing the chair at that time. It's hard to say because we didn't know. And I know that subsequently, when that became known, the later Secretary of State and later Permanent Secretary decided to write a kind of a letter of sanction or censure. But if it had happened at that time when, people were feeling so disappointed by the recusal attempt and by the common issues judgment, felt the post office was still in a kind of denialism, that might have caused them to make that change at that time. I also think that if the clerk advices that I referred to before had become known to the department, that would have pointed to just egregious failings within the post office, because this is people being unfairly prosecuted. I can't think of a worse thing to do. So again, I think that would have absolutely made us bring more extreme changes than occurred.
Just 2 short points finally. One on the issue of bonuses. You gave a fairly strong steer to Tom Cooper in a letter dated the 29th of July 2019 in respect to bonuses. I can put the document up on screen if it would help you.
Thank you.
It's BEIS 5085. And the first paragraph goes straight in to commenting on an email informing you of Post Office's intention to extend performance bonuses to the executive and wider leadership group. And you go on to set out your reasoning for opposing that with express reference to the common issues judgment. If we can just scroll down, please. Over the page, please. Reference to the common issues judgment at the top there. And then the third paragraph down, you say, taking the picture as a whole, the department's view is that executive bonuses should only be paid at a much reduced amount compared to the proposed maximum until tangible improvements have been made. Was your instruction or steer, or the word instruction is used as the title to your letter, but it appears it may have been a steer. Was it followed?
Yes, it was, but it was resisted initially. First of all, they came seeking support for the 100% level, and I was disappointed in that from UKGI because I thought it showed a want of understanding about what had actually occurred, and that doing so would kind of not involve any recognition on Post Office Limited's part, that they, even in their conduct of the litigation, was criticised by the judge, and that was a contemporary matter, even if the matters being looked at by the judge in terms of the historic treatments were from a previous era. So I thought that was a poor judgment from Post Office Limited, from its REMCO, from its Remuneration Committee, which had independent NEDs on, and actually on this occasion by UKGI itself. So I spoke to Tom about it, and he only somewhat agreed with me. I then had a call from the chair saying, oh, everyone should be paid their bonuses in full, and if not, they're all going to resign, and, it's a sort of semi-contractual matter, and there's reasonable expectations and all this type of stuff, which I just didn't accept was appropriate, and that's why I insisted that they make these reductions, why formally they get this letter. As a matter of fact, under the then framework agreement, we didn't have control over remuneration. That was a Post Office devolved matter. If you look at the changes to the Articles of Association made in early 2020, that's one of the things that was added to it to say they would have to get our consent to compensation, including bonuses. So that was, if you like, kind of a new thing that was added because we felt that's not satisfactory, that they should be able to do it. And anyway, nevertheless, it does show that they were very, very clear about our views and about the reasoning, and that's why I set it all through. And I said it's not just me, it's the Minister as well. And they did reduce their bonuses for that reason. Very reluctantly, and incidentally, people didn't resign.
That document can come down now. Just finally, I won't push it up on screen unless you need to see it, but you will have seen in the document sent to you more recently a reference to a meeting at which there was a discussion about the merits of a more limited review into what had happened at the Post Office versus an inquiry. And it seems to suggest that your view and your advice was a more limited review was appropriate. Is that right? And if so, why?
Yes, so my view at that time, which is also the view of ministers, was that we'd had at that stage a lot of findings from the High Court, because we had not just the Common Issues judgment, but the Horizon Trial judgment as well. So between them, hundreds of pages of findings. We actually felt at that time, not correctly as it turns out, but at that time we felt we had a good picture of what had been going on, and the focus needed to be on the Post Office to make recompense, and not just financial recompense, because that is not inadequate itself, but to reform itself, see through the organisational renewal programme, which was initiated in August, and deliver on the 3-year plan, deliver on all the promises made to the sub-postmasters as part of the settlement in terms of the changes to the treatment of them, a whole process of reform. And our concern was that obviously we needed to have an independent review right from the beginning. That was clear. That would be necessary for public confidence, necessary for lessons to be learned, but we were concerned that a full legal inquiry would take some time, and this was a concern that we had in January 2020, and it would cost a great deal of money, and that it would preoccupy the Post Office and take most of their time in thinking about what had happened in the past, which was necessary, but at the expense of what they were doing now and the actions taken in the future. So those were the considerations, and what I've said to you now is exactly what I would have said in those meetings to ministers who at the time were of the same view. In fact, I can see a decision from the then Secretary of State had changed, and it was Alex Sharma by then, and he said he thought it should be done in 4 months and for a budget of £1 million.
So those are all the questions that I have. There are, I think, a handful of questions from several CPs. Ms. Watt, no? I think it may just be Mr. Henry, unless there are any other questions which I'm missing. Just Mr. Henry, sir.
Thank you very much. Sir Alex, the question, what would you have done differently, sometimes invites a self-serving justification caveated with the benefit of hindsight. And you've just been asked about why you thought a limited review was appropriate and asked to reflect on why you came to that conclusion. And as part of your explanation, you said that by that time you felt that you had a good picture of what had been going on inside the post office. When did you acquire that good picture?
I just mentioned that we had the two judgments from the High Court. So I thought they had been very revealing and had, if you like, opened what had been to some extent a black box about the way in which the post office had been proceeding. I think subsequently, thanks to this inquiry, which obviously became ultimately a statutory inquiry, there's been a much fuller disclosure, and some of the documents that we've seen now, not just the Swift report, but I mentioned already those Clark advices internally, we wouldn't have otherwise seen. So I'm grateful that we've got this full disclosure because it's brought us to a much fuller picture. At that time, we didn't know that such bad things have been happening within the post office.
I see. You say, and I don't need, I think, to take you to it unless you would like to see it, but it's at paragraph 241 at page 63 of your witness statement. And you say, among other words, but this is a direct quotation, and it's after Mr. Parker complaining that he felt that the government was too interventionist. But then you say this, quotation, "My reflection is that if we had known what was happening within the post office, we would have been much more interventionist." Now, I would like to concentrate on what you actually knew at the time, not the benefit of hindsight, but what your department then appreciated or ought to have known. What was, as it were, obvious at the time, and so therefore what you ought to have done, not based on hindsight, but based on what your department then knew. And if I refer to shorthand you, Sir Alex, I'm looking at the totality of the framework. First of all, can you help us? You stated that there was an element of denialism that the post office was demonstrating. That denialism was surely clear at the very latest by the time of the Common Issues judgment, was it not?
They had expected to do much better in that litigation than turned out to be the case, and the judge was very critical, as you know, and I've already spoken about. I think their instinct was that was a mistake with the judge rather than a mistake with them, and that's why they brought the recusal attempt, and as we've discussed already, we think that was misguided, and it turned out to be. They also appealed it. The appeal was on slightly more legal grounds, more technical grounds, but nevertheless that too failed. So I think by this time, which is October 2019, you had good evidence that the old post office was mistaken. At this time, we had a new chief executive was appointed the month before that, and he was putting in place considerable reforms, and with encouragement from us, was on the point of trying to settle the ongoing litigation to the satisfaction of the sub-postmasters.
Well, let's try and detach it from the merits, as it were. So you're saying that it was perhaps clearer by October, not by, let's say, the 15th of March 2019. But let's just concentrate for a moment on the costs, and I'm not going to ask you to be precise to every pound, shilling, or to every penny, but your department was facilitating this defence, wasn't it, financially?
No, it wasn't.
It wasn't at all?
No, we already heard some evidence that mistakenly they'd used 2.4 million of departmental money.
I know that
litigation, and that had to be repaid.
I know that got repaid, but overall, when one looks at the way the post office was expending money. Did it not concern you about the legal expenses that it was expending on this, particularly given the remarks made by Mr. Justice Fraser as was about the cost of the litigation and the manner in which the trial was being litigated?
It was with their own resources, but I was concerned, which is why I had been pressing for settlement for a year at that time.
Right. Now, on that subject about pressing for settlement, do you, on reflection, feel that you ought to have been more prescriptive and directive about that, based upon a number of factors, and I want to come to them. First of all, Pol's long-standing refusal to share information. It did not welcome scrutiny or accountability, did it?
I didn't get that impression, no.
You didn't get that impression, but you have spoken about it being resentful about sharing information and also the information protocols. We have seen
Apologies, we're confused. I'm confusing myself or you with my double negatives. Yes, that my impression at the time was that they did not welcome scrutiny.
I do apologise. Thank you. So that must have been a red flag of which you were aware at the time.
Yeah, they didn't refuse to give us information, but I became aware over time of this pattern of, as I tried to describe, stock phrases and rationing of information, a wariness, an institutionalized wariness is the expression that I use there. And that was indeed a concern. That's why we became more and more involved, and that's why we tightened up and required them to give us more information and put in place a new framework of oversight that applied to them. And to the question, should we have ordered them or directed them to make a settlement? I think at that time, it's not clear we had the legal authority to do so. You're probably aware the Articles of Association of 2002 included a power of direction that had been removed in 2013, was reinstated in 2020 during my time, but that wasn't in place at that time, so we wouldn't actually been able to do that. We could have tried in some other means to try and get them to see that they needed to settle. We tried pretty hard on that at every meeting I had with them pretty well. They had, respectable legal reasons for saying that they needed to pursue the litigation. They were convinced that they were right, but also that questions, precise definitions about the duties that are responsible under contract law were things which perhaps did need to be adjudicated in the High Court rather than by means of a settlement. As soon as they'd had the common issues judgment, I felt that's when they should have moving into settlement. That's when they were in a period of denialism, as I've called it, with the recusal and the appeal attempt. And that used up more time, more money unnecessarily, and delayed justice by a further 5 or 6 months.
Can I just test that with you, Sir Alex?
Yes.
Just in as neutral a way as possible.
Mm-hmm.
By reference to the timetable in 2019.
Mm-hmm.
So at the common issues judgment,
Yeah.
March, I believe.
Yes.
Am I not right in thinking that the Horizon issues trial was due to begin within weeks of that?
Yes.
And in fact did take place within a few months of the common issues judgment.
Yes.
So that it's not impossible, I know, but in litigation of this kind, where, as everybody has, I think, acknowledged, there was more to any settlement than simply a financial amount.
Yes, and that was the point that...
It was the actual window of opportunity for a settlement prior to Horizon Issues trial beginning.
Yeah, it's a very good question, Sir Wynne, and I don't think there is a precise answer where there was a perfect moment, and indeed, I think it's more a waxing and a waning. There are various points where there were so-called windows of opportunity for settlement opened up. I felt there could have been one potentially immediately after the common issues judgment, The Post Office, for themselves, decided that they wanted to bring a recusal attempt and an appeal, which I think was launched in May. So then we got the judgment from the appeal, or they got the judgment from the appeal in November, I think. So the whole of issue 1, the common issues judgment, was before the appeal court until that time. As you rightly say, meanwhile, the Horizon issues hearings are underway. The questions which everybody wanted to get to the bottom of was, was this system as good as they said it was? Were there problems with it? Were there errors? A lot of technical evidence there, a lot of asking. Fujitsu were obviously on the stand a lot, who built the system in the first place and maintained it. So there was, I think, you're right to point out very gently that possibly a public interest in allowing those proceedings to bring their natural course. I remained the whole way through of the view that the Post Office was losing, and the longer that they persisted, the worse it was going to be for them, for the postmasters, for their, their customers, their future reputation. And I think that was borne out by the turn of events. So ultimately, they did actually settle, I think, after they'd had the embargo judgment on Horizon issues. The settlement came in December. They'd had the embargo judgment had been given to their counsel, and that also to the sub-postmasters bringing the claimant. So both parties, when they settled, knew that at that stage, the JSFA, the claimants, had won not once but 4 times, both the first 2 hearings and in the recusal and in the appeal court, and that was settled in those terms.
I'm sure you got that right, but even on that, if I may say so, mediation process which led to the settlement had been started in the sense of being discussed between the lawyers and set up before you had the embargo judgment. And I just want to make sure I got this.
and that's right, and perhaps I could just draw your attention to the fact that it was actually a recommended mediation from Justice Fraser as part of his judgment in the common issues judgment in March.
So I just wanted to kind of test, and thank you for your assistance, what actually happened in 2019 in terms of how likely it was that a settlement could have achieved much more quickly, let's put it in that way, than it actually was. So thank you for that. I'm sorry to take over, Mr. Henry.
No, thank you very much, sir. I'm very grateful. So,
finally, from me, this question of a direction, which Ms. Gratton and I had a discussion about this morning. The trouble is that it takes 2 people to settle, isn't it? So even if you said to the Post Office, we direct you to enter into settlement negotiations, it may or may not have happened, is the reality.
Yeah, I think, again, that's very fair comment, Sir Wynne. And, again, when we look at the terms of the settlement, it's not just, it's by no means, only financial. And indeed, it's very interesting. And indeed, in the, I was looking at the press release issued afterwards as well, when I think Alan Bates, includes a quote saying, the thing that he talks about is actually not the financial settlement. He says, look, at last, the Post Office have recognise that they need to kind of overhaul themselves and treat sub-postmasters in a different way. And there's a whole schedule defining all the different things the Post Office needs to do to implement that plan, as well, of course, as the financial value of the settlement itself and the promise of the Horizon shortfall scheme, all of which is set out as part of the settlement. So it was quite comprehensive. But I think what you're hinting at is that it might not have been possible to actually achieve that much before the time of settlement was actually achieved.
That's all I'm saying, because I'm conscious, and this is quite deliberate on my part, so that let nobody be under any misapprehension about this. We're only hearing the Post Office side of the litigation. We haven't had evidence, from Freeths or any of the claimants or anything like that, about how they were viewing all this. So I've just got to be a bit careful, if I can put it in that way.
Okay.
So very quickly.
Anything else?
Can I? Yes, thank you very much. So you accept that there was a window of opportunity before Horizon issues, but you've also, you were observing the trial
we just heard from Sir Wynne there may not have been, but we were certainly saying the whole way along, take every opportunity you can to try and settle.
Exactly. And you were obviously observing the trial. You had a ringside seat, and it was your impression that it was not going well. Is that right?
Somewhat, yeah. So, I mean, the hearings were going on, I think, from November 2018. And certainly I would get reports from them saying, Justice Fraser seems very unimpressed by the post office witnesses. So things like that. I wasn't, obviously attending the trial or reading all the transcripts ending at that time. But and he was certainly critical, I think, in the nature of his questions. You could see that he was unsatisfied. I think, nevertheless, when the actual judgment came in March 15th, it was, I think, quite a shock for a lot of people because it was so critical in so many different ways of the post office. It hadn't simply tried to answer the questions about where the responsibility lay from a contractual interpretation point of view, the sort of technical issues before the common issues part of the litigation, but it actually made a lot of really critical remarks about the post office and their witnesses themselves, and that went a lot further. And also the post office lost on practically every count, which again is comparatively unusual. So
last question. Your page 65 of your statement, Sir Alex, paragraph 249, you said this, I do not consider that there is something inherently defective in the governance structure of the post office. Doesn't that sit ill with what you have said earlier about not knowing what was going on inside the post office?
Well, yes and no. So I think it's an interesting question. I think what I would say is that the setup of having a public corporation with articles of association, with a memorandum of understanding, with a specialist body providing oversight, at that time UKGI, with additional reinforcement from the post office policy team in the department, with defined residual powers given to the Secretary of State, with a framework agreement all in place. That looks like quite a solid piece of governance, and we obviously improved that in my time in the department. However, no structural solution can fully deal with the realities of the situation, which depend on the quality of the people you have in there and their dealings with each other. So I think
So in other words, the last sentence of that paragraph, the board had the prime responsibility for the sound conduct of the post office and manifestly failed to discharge this. So that's bad actors, as it were, concealing information from you.
The board themselves do not appear to have had all the information they should have had. I mean, we've heard already about the Swift report not being given to them.
Absolutely. But can I just, and this was coming to the very last thing from me, Swift was originally Baroness Neville Rolfe's idea. Do you not think that your department ought not to have lost track of that? Because this was originally an idea coming from the minister that there should be a QC-led review to assist Mr. Parker on his accession as chairman.
Sorry, Mr. Henry, is that quite right? It was Baroness Rolfe's idea to have a review. It was, I think I'm right in saying, Mr. Parker's idea to instruct the SILP to assist him.
I'm so sorry. So it arises. I will provide counsel to the inquiry with the.
If I'm wrong about that, you can put me right with the transcript.
Yes, definitely. I will. That was my understanding of her intention at the time, and we will find the document and supply it. What I'm trying to suggest is that there are a series of oversight failures by the department, and that you had found yourself, as it were, in a classic frog boiling analogy, and that over a period of time you gave too much latitude, you were thereby compromised, and then ultimately this resulted in a disaster. What do you say to that?
I don't recognise those phrases or that description, no.
So,
Mr. Henry. I think
you.
you've had 2 last questions now, so that's quite enough.
Thank you, sir.
Is that it, Ms. Price?
It is, sir.
Well, thank you very much, Sir Alex, for making a detailed witness statement and for giving evidence during the course of this afternoon. I'm very grateful to you.
Thank you.
So, tomorrow morning at 10 o'clock?
Yes, sir.
Fine. Thank you very much.
Thank you.